In the criminal justice system, sexually based offenses are considered especially heinous. In New York City, the dedicated detectives who investigate these vicious felonies are members of an elite squad known as the Special Victims Unit. These are their stories.
Hello and welcome to my channel. Today is part 2 to a video that I've made a couple weeks or even months back. You can check it out. In that one, I basically watched the first episode of How to Get Away with Murder, and as a British law student, I basically gave you my thoughts on just how real I thought it portrayed the legal profession. This is of course inspired by countless medical doctors doing this on YouTube, watching medical dramas and basically saying how true they think their profession is portrayed on TV. The same disclaimer as in the previous video, of course, I am a British law student and not an American one, but because of the history between the US and the UK, the legal systems in those two countries are actually the same. The laws are wholly different, but the actual rules underpinning those laws and the systems in the two countries are the same. So I just feel pretty confident speaking about that. Anything I wasn't sure about, I simply researched. So as you know from the title of this video, I will be reviewing the very first episode of Law & Order. This is a very popular legal drama in the US. The first episode of the first season was actually released in 1999, so this is a 20-year-old legal drama basically that I have never watched, and I decided to just start from the beginning. So without any further ado, let us start.
Baltimore, turns out some guy who was getting divorced drank drain cleaner, and when his soon-to-be unmarried widow discovered him dead, no alimony, she stabbed him 15 times out of pique.
So this scene is actually a really good representation of a typical open plan office. I know these people are not lawyers, but detectives. But yeah, from my experience working in a law firm in America, this is very, very reminiscent of that. Obviously 20 years ago, but it still happens today. A big open plan office, people are sharing desks and you know, an open space. Everybody is talking on the phone, everybody's talking to each other, everybody's phones are calling and they're trying to answer and help people. That really does happen. The kind of really prestigious law firm buildings where people have their own offices, you really do need to be in a corporate law setting where you're earning big bucks to see that. This is the Suits style kind of thing, not in like a government, you know, special victims unit kind of a building. The other thing here is those, you know, people talking about those very gruesome things that they're kind of working on in a very nonchalant way, very emotionless way. And that's very accurate as well. When you work in an environment like this and when you're faced with, you know, dozens of people every day who are going through horrible, horrible things happening to them, you really do have to build up like a really thick skin, and you end up talking about it and you seem kind of very maybe rude to some people. To like a lay listener, they would expect it to be a little bit more empathetic, but that's not really what happens after months or years of experiencing that on a daily basis.
Captain?
What?
Desk sergeant just got a call for a sex crimes detective at the 96th Street IRT.
Why?
Some guy molesting a dead body.
Oh, that is just terrific. Who's up?
Me and Munch.
Well, listen, I think a dead molestee can be handled by one detective. Cassidy, you go. Munch, give Stabler and Benson the benefit of your vast puncture wound experience.
Sir, if the body's dead, then is that considered a sex crime?
Just go. You know, investigate, interrogate, write up a DD-5.
So to answer this guy's question, in different jurisdictions, necrophilia would be considered something else. Perhaps it might not be criminalized, perhaps it might be a different category of a crime, but I researched it, and in New York State, having sexual intercourse with a dead body is actually considered sexual misconduct. So this is found in New York Consolidated Laws, Penal Law, and this is Rule 130.20. And forgive me if I'm reading this wrong, if you know how to read these, you know, codes, numbers, or the rule numbers. It's different in every jurisdiction, so to me it's Rule 130.20. And it says here that a person is guilty of sexual misconduct when, and number 3 says, he or she engages in sexual contact with an animal or a dead body. and this is a Class A misdemeanor. So yeah, this is considered a sex crime in New York State, and something like the Special Victims Unit would totally have to deal with that.
Why don't you follow over the cab company, because the night guy didn't have a home address on the Vic. I'll do the hack bureau.
So this woman, who I don't know the name of, but she actually, I think, turns out to be the main protagonist of the series. She used the word Vic, the address of the Vic, and I'm pretty sure she's referring to the victim of whatever case she's talking about. From my own experience, however, in British law school, in British law firms, and in American law firms, I have never heard the victim to be referred to as the Vic. Usually in spoken word, it's simply the victim. In written word, you usually just say V. You would refer to the defendant as D, the victim as V. Sometimes in spoken word, you would say those as well. You would just say the V was 25 years old or whatever. I've never heard anyone say the Vic. This is the first thing. But again, maybe in this office or maybe in New York State, referring to the victim as the Vic is a thing, but not according to my experience.
Weenie wagger.
Detective Stabler, you previously testified.
So I'm a little bit confused by this part because it's said that it's Supreme Court Part 72, and then you have this very, sassy lawyer kind of interrogating this detective. So what I want to say is that if this is suggesting that this is the Supreme Court of the United States, well, that's clearly baloney, because, you know, a normal kind of sexual misconduct case would not be in the Supreme Court. That's one. Number two is that there is no interrogation or jury or witnesses in the Supreme Court. In the Supreme Court, you always only argue on the point of law rather than point of fact. So we only argue the decision made by the lower courts. So what this means is that at trial, every kind of fact of the case is established by interrogation, by the jury, by witnesses, by evidence. And then those facts, when they are settled on trial, are taken as true. So whether this goes to the Court of Appeal or the Supreme Court or anywhere like that, those facts are not argued anymore. What the lawyers will be arguing is that the law that is applying to the defendant or the victim or the circumstances should be read or understood differently, or that a different piece of law should apply to the circumstances, not that something happened or didn't happen. This is obviously not the Supreme Court, even though it said Supreme Court Part 72. So a normal viewer might think that this is the Supreme Court. I tried to Google Supreme Court Part 72 New York State and it didn't give me anything. What I think it might be is just a division, like a lower division of a courthouse within the Supreme Court courthouse. I'm not really sure, but this is definitely just a normal trial and not the Supreme Court.
Four children, none of whom I'd like exposed to Mr. Gloucester's shortcomings. Shortcomings.
Oh my god, stop. Oh, fuck me. Yeah, I think it doesn't need explanation that indecent exposure is definitely a crime, and doing it in a courthouse would probably get you done for contempt of court as well. There's definitely at least a few things that this guy has done wrong to break the law in this scene.
Still reads gay to me.
Okay.
Panachek's prints are clean here, right? Yes, so let's do this by the numbers. He's illegal, send a set to Interpol too. Forensics report. What? They found part of a fingernail in the front seat of the cab.
Gasp.
With red nail polish on it.
Red
The
nails.
dispatcher said he thought it may have been a woman who called about Spicer.
Kinda undercuts your gay theory, huh?
Could be a he, she.
Didn't do us.
This is so bad. So, I don't know what the fuck is wrong with wearing nail polish and being a man. But you know what? I have bad news for you. If you are a guy and you wear red nail polish, this guy is saying that you are not in fact a guy, you are a he or she. What? What even is that? I know that this is from 1999, so this is 20 years ago, and this entire episode is pretty homophobic. But you know, I think it's kind of funny right now.
Marty Detective Olivia Benson, New York City Police Department. How can I help you? Just want to talk to you for a minute. Is there someplace more private?
Shouldn't be doing that.
What's this about? I just wanted to ask you a few questions. Would you mind letting me look at your hands, please?
So this is not okay. What is happening here is that she is off duty. She doesn't have her partner with her. So she's a law enforcer, a detective, a policewoman, whatever you want to call that. And I couldn't find this in New York State law, but there are laws, rules of conduct, rules and regulations that apply to police officers on duty. And this is clearly breaching, like, some rule in one way or another. What I mean is that because she's off duty, she is not allowed to interrogate anyone. Interrogation, legal interrogation by a police officer is a right given to police officers. I can't interrogate you legally because I'm not a police officer. And so when those people are on duty, that is the only time when they can use those privileges that are given to them that are not, anointed to normal people. So what she's doing is using her police privileges while she's not on duty. This causes a number of problems. Basically, if she wanted to use evidence of what this woman said as a witness in court, it might be quite difficult for her to explain that this is good evidence, or for the judge to accept that as evidence, because she took it in an improper way. So this kind of gathering of evidence or interrogating suspects or witnesses when you're not allowed to do so, when you're not on duty, or when you've not been instructed to do so by a sheriff or whatever it is called improper evidence, improperly obtained evidence. This doesn't necessarily mean that the evidence will be thrown out. If something that she says is very useful to the case, it might still go through. But she's definitely, getting herself in trouble here, at least with, her own department. So yeah, should not be doing that.
Sometimes he was too drunk, so he did it with whatever was there. A wrench, a pistol, a broom handle.
So this is obviously a very serious scene. This is a TV series, but it talks about something that happens to people. It talks about a real issue. So the only thing I want to say there as like a point of law, I think, the way this would be handled in a court of law is that inserting a foreign object into somebody, whether it's orally, anally, or vaginally, is not considered rape in most jurisdictions. For rape to occur, it needs to be a penile penetration of another person. So this doesn't make a big distinction, it's just the naming of the offense. The offense like this, like she's explaining, would probably be called something like sexual assault by penetration, and most of the time they just carry the same sentence as rape, and especially in these circumstances it would carry a very high sentence. So it doesn't really make a difference, it's just called something else, so I thought I would bring that up.
It could be them, but I told you it was very dark where they crossed the street. Yeah, it's okay, just take a look at them. Take a look at them. I could look at these all day, but it wouldn't do any good. I'm sorry.
So this is a little bit difficult. I'm going to draw a distinction here. So basically these detectives are kind of asking this guy about whether he can recognize these two women from the pictures to lead them to these women. If they were to use this guy as a witness in court to show that those women, that he actually saw these women there are many problems with the way these people are doing this. Number one, you couldn't use that as evidence. I mean, he's literally just standing on the street. You need to take this person into the police station and do it properly, just like any interrogation of a witness. Secondly, you cannot just show a witness the two pictures or the one picture of the person that you want them to identify and for them to say yes or no. You have to do like an ID parade or something. This was 20 years ago. Right now this is all computerized. The person would be shown like pictures on the computer screen. But 20 years ago, ID parades were a thing. You need to show the person fake people so that you can ensure that their memory, their recollection of the events is accurate if you're going to use that in court. You know, this could just look like someone else that he thinks he saw. It's not good evidence to point to this one picture and say yes or no. You have to have a range of pictures of people who are not the suspects and ask the witness to point to them and not do that in the middle of the street. The other thing is that visual identification evidence in court is usually very poor evidence. This is because, well, for real reasons of the fact that we are mistaken. An honest witness can be mistaken as to who they think they saw. I mean, I don't know if it happened to you ever, but I mean, you could be walking on the street and, you know, think you saw your friend, and then you message them later like, why didn't you say hi to me? And they said, oh, I'm actually out of town, I didn't see you. It's common. People think they see different things. And he's saying it was dark and across the street. This is very, very poor evidence. This would not stand in court. What I understand is that this is leading them to like a different clue or something like that. So that's fair enough, but this is very poorly carried out, and this would not stand in court as good evidence.
We don't have a case.
Oh, yeah, we do.
There's no proof.
They don't know that.
Elliot.
We're arresting them now.
A first-year law student will have him out in 20 minutes.
Not if they confess.
I'm not.
Yes. Yeah.
Would you please stand up, Mrs. Stevens? What's this about?
Murder Stevens, you're under arrest for the murder of Stefan
So
Tanzer.
this woman here was actually correct. These people, all the evidence that they have on the older lady is that she had red nail polish, the same that was found, not DNA matched, red nail polish that was also found in the taxi, and that her hand was injured. And then this other woman, well, there was nothing on her, and her fingers weren't painted red, and she even said she was at work, but with no one else there, so it's a poor alibi. But they don't actually have any active or positive evidence against those people. I know they're basically fishing for them to admit their guilt, but it should not be done that way. Even an admission of guilt can be challenged in court. A defense lawyer can say that the person was, I don't know, in fear, or whatever the circumstances were and whatever the jurisdiction allows for, whatever the New York state allows for. Admission of guilt does not automatically mean that the person has to go to jail or the person is guilty. The person can, upon contacting the lawyer, say, well, you know what, I didn't mean what I said, let's kind of reverse this back. That is possible. You can obviously plead guilty in front of a judge, and that's fine, but admission of guilt on its own in front of a police officer that is, you know, telling you need to tell us, that doesn't always fly in court.
Listen to me. I know what a shock it must have been to see Tanzik in that cab. Don't talk to anybody without talking to your lawyer. No one, say nothing.
This is obviously very inappropriate. I can't really think of any kind of rule of conduct that, you know, this woman is breaking right now, speaking to the suspect in that way. But the problem that does occur is the fact that she basically is giving her legal advice, but she's not a lawyer. That is absolutely not okay. She is saying that she needs to just remain silent, and you may mistakenly believe that that is always the best case. From a lot of legal dramas, everyone says, I plead the fifth, especially in America, and I'm not saying anything. Especially in the UK, but also in the US, a little bit less in the US. But silence can point to guilt of the defendant sometimes. There is some case law on this, very, very limited, because obviously to plead the fifth is like a constitutional right of a person in the US. But there have been scenarios in which a person staying silent, where an explanation would be reasonably expected from them, would point towards their guilt. And it's not always the best advice to stay totally silent and not say anything. I'm reading this from a website, the San Diego Union Tribune. This is just a newspaper, and I know this is in California, but a lot of this kind of high-level criminal law can circulate around the US and can be at federal level sometimes. So this is not without any repercussion for like the New York state, for example. So it says here that People versus Tom, California Supreme Court justices upheld the prosecution of a man based on the district attorney's argument that the defendant's silence was evidence of guilt. It further says that the officer reads the suspect the Miranda wording, which is, you don't have to say anything, anything you do say will be used in court against you. And suspects can then clam up and wait for an attorney. In real life, though, these matters can become more complicated and legalistic. There's basically a distinction between a person not saying something and between the person outrightly saying, I am invoking my Fifth Amendment rights. And sometimes if you don't say that, it can be difficult. There can be so many different circumstances that in a reasonable person's mind would kind of make you think, this person should have really said something and not stayed silent if they weren't guilty. They should have explained themselves. So it really is not the best legal advice to never say anything, and especially coming from a detective and not a lawyer. That's very, very inappropriate.
I've got to run it by shift, but I'm willing to take a plea on this.
Man one?
I'll take man two and smile. Severe emotional distress. I sure as hell don't want to go to trial. All they've got to do is get Tanzik's war crimes indictment in and her friend's suicide, and she'll get a walk.
How much time?
My guess, if they get the right judge, she'll get 18 months in a psychiatric.
So there are a couple things here. When he said man one and she said man two and we smile or something, they're referring to second and first degree manslaughter. It's called second and first degree in New York State. In a lot of jurisdictions, this is called voluntary and involuntary manslaughter. So in the New York Penal Law Code, Part 3, Title H, Section 125.15 describes what manslaughter in the second degree is. This would be involuntary manslaughter in a lot of other jurisdictions. And it says here that a person is guilty of manslaughter in the second degree when 1. He recklessly causes the death of another person, and then recklessly is further defined in legal terms. The reason they can't really pursue a murder charge on her is because that requires intent to kill, and basically she kind of got into the taxi and then realized that this was the man that had been raping her for so many days, years and years ago, and she went into panic mode. She didn't know what to do. She started stabbing him. It would be very, very difficult, if not impossible, to prove that she intended to take away his life. It's a way too high of a threshold in this scenario. So then recklessly can be defined, in a more lower threshold, and that she maybe wasn't sure of what she wanted to do, but she was stabbing him, and as a result of her recklessness, basically she didn't care whether his life would be taken away or not. She didn't care whether her actions would cause him to die, and she just kept going. And so this is kind of recklessness in this scenario. So there would be a couple of defenses available to this woman. I couldn't find anything in this penal code, in the actual code, because for second degree murder, which is just normal murder that's not of like a super important person, it says that it's an affirmative defense that the defendant acted under the influence of extreme emotional disturbance for which there was a reasonable explanation. And I feel like that would be a really good defense for her if they try to charge her with second degree murder, is that she was in such an emotional shock and all of these things happened. She was, disturbed emotionally. But that defense does not seem to be available for second degree manslaughter, and the only thing that you can then use to defend is that Well, there are a couple. One of them that could apply to her is that she was of unsound mind, so basically she would go to a psychiatric ward instead, which is probably what this woman was referring to would happen. And then the other thing is, I guess, basically to argue that not all of the ingredients of the offense have been satisfied. So mainly that she actually wasn't criminally reckless to do what she did. That, you know, her actions or mens rea was a little bit lower than recklessness. This was probably not really possible to argue in the scenario that this happened in, but it leaves me a little bit baffled by the fact that extreme emotional disturbance is not a defense to second-degree manslaughter in New York State, but it is to murder. This is just from my very quick research, so it kind of is confusing to me, if you like. But this is what it is. So second-degree manslaughter. The next thing that this woman says is that she doesn't want trial. She just wants the person to plead guilty. Because at trial, the jury would just let her go if they just knew, you know, the past of the victim. I don't know that it's entirely true. The jury can't just let someone go because they sympathize with the defendant. They are given a set of legal rules. They are given a set of legal questions that they have to answer very narrowly. It doesn't just mean that, oh, well, you know, we would have done the same in the same scenario. No, the judge will pose the jury very, very particular legal questions that they really don't have that much leeway in answering sometimes. For example, the jury could be asked to rule on whether they think the defendant was reckless while stabbing the victim, and they would be given all of this evidence to show that 37 stabbing wounds are obviously going to kill someone, that she was angry and that she was enraged and that she had a knife with her, and that you know, after one or two stabs that she clearly must have, you know, knew what she was doing, and that she continued stabbing. And really, in all of that kind of painting of a scenario of by the prosecution of the defendant's mind, the jury can't really come back and say, no, we actually think this was fine. They have a very limited kind of leeway, so I don't think they can just let someone go because they sympathize with them. And then lastly, in sentencing, this woman says she might get 18 months in a psychiatric ward. Sentencing is very, very difficult, and really only, you know, practitioners with years and years of experience who basically know the judges that they're going to be pleading their case in front of can really guess accurately. I mean, for Class C felony, which manslaughter and the second degree in New York State is considered, the sentence that this crime carries is up to 15 years. So really, there is so much leeway that the judge has in the sentencing period. That there's so many things come into that. There is no way to guess. I say 18 months in psychiatric ward, sure, why not? Probably true. The last thing I just want to point out, and I've kind of already said this, is that if the defendant decides to just plead guilty and not argue her case, the judge will just hear her case and then sentence appropriately, and there will not be a trial. The trial only really works if facts are in dispute. So if the prosecution says you did this and the defendant would like to argue, no, actually I didn't, that's not exactly how it went down. So I mean, if she's going to plead guilty, sure, no trial, she is going to get whatever sentence judge thinks is appropriate. But like I said, she can, even though she confessed in front of a lawyer, in front of you know, police officers, she can't take it back, really, and she can't try and argue that she was coerced, she wasn't thinking what she was saying, she was upset, whatever, all of these things, whatever the law actually allows for. So this was kind of a longer video. I don't know how the editing of it will go down. It is quite technically difficult for me to insert this little video to play next to me, but I hope it all works out. I hope this was useful, and I hope this was like fun or informative in any way. If you'd like me to do any more of those, just let me know down in the comments below, and why don't you check out the rest of my channel? It is nothing like this, but I'm still the same person and I do what I love, and you might just fall in love with watching what I do. So I invite you to check that out. But subscription to this channel, as always, is very optional if you decide to subscribe. However, I hope you enjoy your stay. I'm going to see you in my next video. Bye!